So welcome back. Let us start with the class where we have left. Today we have taken, let me have a quick review of what we did in our class. Today we had a little different time because it is the first class. We need to cover so many things apart from the syllabus. We need to have an overview of our subjects. We need to have overview of the exams. We need to discuss many things to get conversant with each other. And let me say you different thing before I start with this today's class. My face may be looking little brighter because the sun is rising in my at my place, and it's the morning time in India. In morning time, sun is exactly in front of me and in my office where I'm sitting. So with the sun rising and our lives are also rising to become barrister and solicitors, let us start with the remaining part of our class. And I will be very time constraints in the classes to come. And let me say you one last thing about our schedules. Our class will be for 3 hours. We will be having 15 minutes break every time we have a class. And generally our break will be scheduled at say 8:15. So you can, as per Indian times, mean to say after 1 hour 15 minutes from the class time. Once we start the class, 1 hour 15 minutes, tentatively it will be at yours 9:45. 9:45 in Ontario and 8:15 in India will be the break time. 15 minutes break will be there. After that, we will be having 1.5 hour class. So before break, 1 hour 15 minutes. After break, 1 hour 30 minutes. But this is not a strict schedule. Once we go with the regular students, then of course everybody's consent will be required that how they want to format their class. But that is my suggestion to all of you. Let us come back to our syllabus. We have done till time the jurisdiction and organizations of courts of Ontario. We have dealt with language part, Court of Appeal for Ontario, Court of Ontario, Superior Court of Justice. We have already studied that case management masters are no more known as case management masters, but associate judges. And we have know the exceptions for hearing of the associate judges, which is the important part. Then comes the duties of the registrars. And by knowing all these things, assessment officers as well of the Superior Court of Justice, one conclusion can easily be drawn. That is that how the courts are very less burdened in Canada. And let me say you one thing more in the first class itself. Why I keep on giving these remarks? Are these a part of our syllabus? No, this is a part of our teaching. Why so? Because once you are live in the class, your brain will always be fresh to grasp new facts. But if I do not talk anything else and keep on just reading and explaining the concepts, then so many concepts are there. It becomes cumbersome procedure to grasp things. So to best of my mind, grasping needs break. Break every 5 minutes, break every 7 minutes, break every 15 minutes. And telling you something else apart from this syllabus is a break point. Now let us continue. Today I'm telling more about my methodology of teaching and conducting the classes so that whosoever will be seeing this recording or attending my class today will be at ease to go for the classes. Let us come to divisional. Okay. I had the other methodology to start, but I do not want to controvert with the LSO material. Why so? Because I wanted to say you something else, that whenever you are to go, where you will go as a new lawyer, in the hierarchy to the lower courts. In the hierarchy, I'm saying to the lower courts, then little upper court, then the second upper court, then the topmost court. This is something which Everybody does. But the point in question is, LSO has designed this material and written this material accordingly. So I have to formulate the same formula. Now let us talk about divisional codes. The divisional code is a branch of the Superior Court of Justice. It's exercise appellant jurisdiction pursuant to section 19 of CJ, judgment, orders, appeals, enforcement, and cost of these study materials for specific appeal rights to the divisional courts. In addition to its appellant function, the divisional court also exercise original jurisdiction in applications for judicial review of administrative actions pursuant to section 6(1) of the JRPA. One of my learned friend had asked me the question. I told him to bear with me. I suppose this line finds the answer. I have a pencil, and today one question is there, and I have written on my notes question. Whenever I talk about question, it is good to write with pencil Q, because whenever you are to refer to these spaces for the purpose of revision even, Q will trigger your mind that this can be an exam question. So original jurisdiction in applications for judicial review for administrative action pursuant to section 6(1) of the JRPA. The Chief Justice of the Superior Court of Justice is the President of the Divisional Court. Although every judge of the Superior Court of Justice is also a judge of the Divisional Court, in practice, Superior Court judges rotate through the Divisional Courts from time to time as Chief Justice designate. The Chief Justice has also appointed 2 Divisional Courts administrative judges to oversee its administration. Now, let us visualize another scenario. Another scenario is that first we have discussed about Ontario Court of Appeal, then we came down to Superior Court of Justice, then we came down to Divisional Courts. Now, Divisional Court is such a court which is in the reach of most of the persons, most of the lawyers. So it is on territory basis. It is something on like you have to be very specific, you have to be very clear that there are various divisional courts. Once there are various divisional courts, meaning thereby it is territory based. So to look after the affairs of the divisional courts, there are administrative judges appointed for a particular set of courts or court from the Superior Court of Justice, and they look into the affairs of the divisional court, each divisional court entrusted to them. Now, proceedings in the divisional courts are heard and determined by 3 judges sitting together. One judge may preside where appeal is from a final decision of an associate judge. The appeal is from a final order of the small claims court by a provincial court judge, a deputy judge in a small claims court, or the small claims court administrative judges where the amount in issue or the value of the property in issue exceeds $35,000 in value, or the matter is one of the Chief Justice of the Superior Court of Justice or a judge designated by the Chief Justice is satisfied that it ought to be determined by one judge for reasons of expeditions and the nature of the issue involved. A motion in the divisional court must be heard by one judge unless the rules of the court provide otherwise. Although the judge may adjourn the motion to a panel of divisional court, a panel of divisional court may on the motion set aside or vary the decisions of a single judge. What I am trying to explain by reading the whole paragraph, that generally these are the 3 judges which hears the appeal, which hears the matter in question in divisional courts, but one judge can decide about the motion. If request for motion is there, one judge can decide whether we can go ahead with this motion or not. A panel of divisional court may on motion set aside the or vary the decision of the single judge. We will read it in detail, but for structural purposes, these somewhere appellant jurisdiction has been discussed, somewhere value has been discussed, or somewhere the manner has been discussed in which the cases are taken up. An appeal to the divisional court must be heard in the region in which hearing or the process that led to the decision appealed from took place. Unless the parties agree otherwise or the Chief Justice of the Superior Court of Justice orders otherwise, because it is necessary to do so in the interest of the justice. Any other proceedings in the divisional court, such as a judicial review, where the court exercises original jurisdiction, may be brought in any region. Now, liberty has been granted that you can bring it in any court of any jurisdiction once it's a matter of judicial review. What is judicial review? Simple. I'm not talking about technical legal definition of judicial review. You are not satisfied.
Sir, appeals from tribunal, the administrative bodies. Appeals from
Yes,
the
yes. I can. Everybody can, I suppose, understand. You are very good, gentlemen. But the point in question is, judicial review is you are aggrieved from a quasi-judicial or a non-judicial body, and you want that the hearing must be done by some judicial body. That is how I interpret it. What is judicial review? You go judicial, one word, review is another word. Let me say you one thing. Go to the normal practice. What is LSO exam? They are expecting you to be barrister and solicitors in the times to come. And you have a visualization. What is that visualization? Some person is aggrieved from the electricity tribunal. Some person, you are not able to decide what can be its jurisdiction. Any divisional court can be approached for the purpose of judicial review, because you are knowing that either the non-judicial body or the quasi-judicial body has made a decision on in the instant matter. Now you want to get the redressal done by a judicial authority. Once you start thinking in these terms, Immigration Board has done a decision. Now you want to go to judicial review. Where you will go? Immigration and Refugee Protection Board? No. Why not? Because that is not a judicial body. So there are hundreds of administrative. NCA has got its own administrative tribunal. Appeal mechanism is there, and that body which decides about it, appeal is known as administrative body, administrative tribunal. So there are thousands, or if not thousands, hundreds of administrative tribunal, the decision of which needs to be reviewed by the court. And that is why it has been held that any divisional court can take up the matter if you are undecisive where this application for judicial review with respect to the jurisdiction should go to. Because once you are good with the divisional court, you are good with the Ontario Court of Justice, Ontario Appeal Court of Justice, then Superior Court of Justice, Divisional Court. This is the basic structure we are studying. Once you have everything deep imbibed in your mind, then it is very easy to understand the whole of the civil litigation. You came to know the moment client is sitting before you that where to go, where to take his case. Half, say 25% of the matter is done. Because in Canada, result does not matter. Similar is the case. The client is going to watch you how much effort, appropriate efforts you have put into it. Of course, the result do matters to the client. But during the whole process, the client is watching you whether you are the right person whom he has engaged or not. Till the decision is made, or even after the decision is made in his favor or her favor. Even then, he will keep on analyzing a barrister and solicitor that whether he engaged the right person or not. So that is what you can learn from LSO material. I, I will give you one instance. Of course, the most relevant with this um, syllabus. I myself went in Ontario. Of course, now I'm in India. I went in a court, in a lawyer's office. We were sitting for the whole day. I was doing something. My colleague asked me which court needs, where we need to file this. There was a situation where we need to decide. He asked me, do you have LSO material ready with you? I was really good to know that LSO material is there to give us the real picture in practice. Why so? Let me say you. If you go through the uh, minimum competencies expected by the LSO, which I have posted in the group, in minimum competencies, you will come across in barristers approximately, I have not counted, 100 bare acts. 100 bare acts. So to get a answer to a single question, you need to go to specific bare act, or you should have a methodology to understand that. You should have access to all the bare acts, or in the alternative, you should have access to LSO material. Once you will have it, now if you will ask me how it is possible, once you will shift yourself to the practice, you will be really thankful to LSO, not to me, LSO, Law Society of Ontario, that they provided us with the crispy material, not only for the exam purposes, but for the practice purpose. You need to go for HST calculations, go to LSO material, accompanied by some other things as well. You want to calculate LTT, land transfer tax, go to LSO material. You want to have a reference of a crispy section of a particular act, go to LSO material, provided you know that where it is, like in the exams. So let us come back to our daily reading, small claims court.
Sir, one question.
Yes,
Uh,
please.
for for the division code last paragraph which you read, so there were two things in that. One is first an appeal to the division court, and the second four lines, any other proceedings in the division court. So
Kindly read,
there
kindly
can
read, kindly read.
okay, I'll read the full paragraph. An appeal to the divisional court must be heard in the region in which the hearing or other process that led to the decision appealed from took place, unless the parties agree otherwise, or the Chief Justice of the Superior Court of Justice orders otherwise, because it is necessary to do so in the interest of justice.
Full stop.
So, yeah, so in this case means that any appeals from the admin body will go to the divisional court of that region,
Okay,
unless
kindly read.
there are two. Yeah,
Kindly read the further few lines.
yeah, and the second thing is any other proceedings in the divisional court, such as a judicial review where the court exercises original jurisdiction, may be brought in any region. So can you just like explain a little bit on this, the
Yes,
last one?
yes. That is what I have referred to the last 3-4 minutes discussion. That judicial review meant that you do not know that appeal to which jurisdiction. Suppose your decision has been made by Immigration Fusee and Protection Board, Immigration Board, commonly known as. You do not know which jurisdiction immigration board is situated at one place. Whether you are situated in, say, go to page number one, we are in this Hamilton, and whether immigration board is in Toronto, whether we should file this to the divisional court of Toronto or to the Hamilton. That is what the question is. So the law permits you either go to the court of Toronto and go to the court of Hamilton for the purpose of original jurisdiction, for the purpose of judicial review. We were talking about immigration. So the law permits you, if you are undecisive about the jurisdictional part, about the original jurisdiction of judicial review, then you can go in either in Toronto or in Hamilton. Am I clear, friend?
Yeah, thank you, sir. Thank you.
And believe me, I cannot, due to some medical emergency, I cannot silent my phone. That is why I have kept it open. So please don't get disturbed because of its voice. Thank you. Okay, small claims court. The small claims court is another branch of the superior court, and it has jurisdiction where the amount in issue or the value of the property in issue does not exceed 35,000. I made an error of writing it 25,000. I never amended that chart. 25, 35. Now let me make a remark. I cannot leave this remark. This is something extra. Please don't quote me, although it is being recorded, but please don't quote. Earlier it was 15,000, then it is 25,000, now it is 35,000. In small claims court, paralegals can appear for a client. Now, by increasing this threshold limit, work is receding from barrister and solicitors to paralegals. Small work, of course. With all pardon, all apologies at my command, I'm submitting that law is taking work away from lawyers to the paralegals, not to court. Okay. So this is amendment is future amendment is not expected. This may be enhanced to 50,000. That is in the pipeline. By the time you may appear in the exam, because generally speaking, these sort of amendments comes in January, please do check. Of course, an amendment will come in your LSO accounts, but please do check before finalizing 35,000. This court is meant to provide a more accessible and less formal way of litigating disputes in a case with a counterclaim called defendant's claim in this court. The court can hear a case with a 35,000 plaintiff's claim and 35,000 defendant's claim, thereby putting 70,000 in dispute in small claims. If at all a question comes on this 35,000, it comes in this mixed scenario. In the exam, you may jot down on your LSO material question. What is the question? There will be a scenario. In these days, LSO puts scenario in every question. This has started with my batch in the June 2021, sorry, 2021. It started, but now it is a continuing process. What is that process? LO gives you a scenario where you will be looking for 35,000, but the value will be given of, say, 58,000. And you will immediately pick up that one. 58,000, value is 35,000. Okay, it is not the cup of tea of small claims. Go to somewhere else. I do not admit, because you haven't read the question. You should read the perplexity of the situation, that from how much comes from whom, how much is A's claim, how much is B's claim. B is on, say, A plus B equal to C. C is on the other side, A plus B you have to calculate. Means to say plaintiffs are A and B. Taken together, their claim is of $35,000. Okay, done. Then another guy, $23,000. Total comes out to be 58. But I changed the scenario. If anybody's single party's claim, either plaintiff or defendants, goes beyond this limit, then it comes to be small claims. If it goes beyond, then it is not small claims court. If it is below, then it comes to be 35, 35 means to say 70. Tomorrow, if it goes to 50, 50, 50 comes out to be 1 lakh, 100K Canadian dollars. So kindly be prepared for these sort of questions. Another set of questions in the exam, our every class will be a workshop. Otherwise, we will have separate workshops, but every class will be a workshop where you will be directly conversant with the questions coming in the exams and the manner in which the examiner is going to test you on that particular topic. Let us go further. The court does not have jurisdiction to try actions.
Excuse me, sir.
Yes,
sir,
please.
I'm really sorry. Can you please explain this 35,000 that claim part once again? Like,
Yes,
suppose you said that there are two plaintiffs and one is on the defendant side, A and B are on the plaintiff side. Can you please repeat that part once again, please, sir?
you're most welcome. I will. And the point is 35,000 A, say A versus B. A should be 35,000, B should be 35. Now split A into A1, A2, A3, three persons. One has got a claim of 12,000, another has got a claim of 12,000, another person has got a claim of 11,000. Total comes out to be 35,000. Okay, done. This comes under the preview of from the plaintiff side. Similar is case in the defendant side. Now, say A1, A2, A3 has got a claim of 12,000 each. It comes out to be 36,000. Does it come under the preview of small claims court?
No, I think the amount has increased to from
1,000.
beyond 35,000. Yes.
Now, next point. If they can lower their claim, anyone agrees, I can lower it by 1,000, then it can. Now comes to the defendant side, same is the scenario with the defendant side. So it is not 35,000, it is 70,000, double. And you have to make a chart in your mind. With the flick of a second, you will have the answer. Who are the plaintiffs? Who are the defendants? The plaintiff should have 35,000, defendant should have 35,000, 35,000 each. Good to go with the small claims. Increased one side, goes beyond that? No. People commit an error. Once 36,000, the defendant has 23,000, meaning thereby you will have to think in a precise manner in the exam. Am I clear, ma'am?
Yes, sir. Yes, it's clear now. Thank you.
So nice.
Oh, nice.
And
Sorry, I have a question.
please go ahead.
So, if this current scenario is in matters where there is a cross claim by the defendant, but let's say if there was no cross claim,
35,000? Sorry,
I'm
you
sorry.
haven't asked. Sorry, I interrupted. Sorry.
No, so I was saying if there was no cross claim by the defendant, then still we are looking at only 35,000, or would that increase the plaintiff's claim?
No, it will
Still
not
30.
increase. 35,000 only. If it go to 36,000, if you can lower, as being a plaintiff, if you can lower your claim, then it can come.
Okay, okay. So, despite of the fact that there is no counterclaim, still the limit remains for each side as 35,000.
Yes, A versus B. A is equal to 35,000, B equal to 35,000. A is
Perfect.
plaintiff, B is defendant. Now, let us go further. The court does not have jurisdiction to try actions that exceed monetary limits. Even the consent of the parties, however, where liquidated damages were involved, with both the plaintiffs and defendant each claiming 25,000 against the other, a small claims court at that time, the divisional court in court versus so and so Ontario Incorporation held that it was the proper for the small claims court to review the amounts claimed by the parties, and even though one party was found to be entitled to 42,633.57 and the other party entitled to 21,094.72, the net claim of 21,538.85 was within the small claims jurisdiction. Now, this is an exception which has come on the play by way of we are in a common law country. We have to respect for the court judgments. And what is the court judgment? 2146100 Ontario Limited versus 2052750 Ontario Incorporation. What is the judgment? This is something away from the rules. Away from the rules. Do not ever consider in your exam question away from the rule. You need to stick to the rules. What is the rule? I have already told you. Now, what is the point? If one is Cross claim is there, as ma'am was saying, cross claim is there. Cross claim is to say you have to adjust. You have to adjust whether this amount comes below 35,000 or not. As the figure suggests, in this case, the amounted claimed came below 35,000, the court allowed. Small claim, court jurisdiction. But to be on the funny side, I have already stated, though just for the purpose of exam, it is correct. It is not liked by barrister and solicitor because generally speaking, small claim goes out of the preview of barrister and solicitor. With apologies and all the respect at my command for paralegals. Although Section 96(3) of the CJA appears to preclude equitable relief in small claims court, the Court of Appeal in Grover versus Hodgins held that the small claims court does not have jurisdiction to grant equitable relief where the amount of money or value of property in issue is within the monetary limit of small claims court. Although not strictly before the Court of Appeal indicated that similar language in Section 97, apparently precluding declaratory relief, did not deprive the small claims court of the power to grant a declaratory judgment where the amount of money or value of property in issue was within the monetary limits of the small claims court. The similar things have been, I could have skipped this paragraph. Next paragraph is very important. The Divisional Court in Luo versus Canada Attorney General held that the small claims court could hear a suit against the federal crown that was within its monetary jurisdiction. This is something piece of information. Now going to the last paragraph. 50 judges may also be appointed pursuant to Section 32 of the, this is something about the structure who can be appointed. A deputy judge is a lawyer. I am just pointing out a lawyer can be appointed as a judge of a small claims court. A deputy judge is a lawyer who has been appointed by a regional senior judge of the Superior Court of Justice with the approval of the Attorney General. A proceedings in the small claims court is heard and determined by one judge of the Superior Court of Justice. A provincial court judge appointed prior to September 1, 1990, a deputy judge or the small claims court administrative judge. Now, if you like me to interpret it, I am not ready for it. Why so? Because it is always ticklish to interpret that who is to be who in which court. If you go into your regular practice, you will come across that you have always to consult the roster. Why so? Because roster tells you what is the current scenario. So there is no fixed formula. That is why LSO is reluctant to ask you questions. Now coming very important, because this is a question which is almost your one question in any manner is sure. Today, out of your class, I do not know how much marks you are going to obtain, but these marks are sure. Kindly write down question. This is hearsay evidence. Generally, examiner always asks in any manner whether hearsay admissible is permissible. This is not the exact question I'm speaking. Hearsay evidence is admissible. Of course, a scenario or a particular question is there. Here, up to the level of reading, hearsay evidence is admissible or not? The answer to this is yes. Big yes. But we have learned in common law countries, hearsay evidence is not admissible in law. That is one exception. Here we will find hearsay evidence is admissible. How so? Let us read. The small claims court has a statutory mandate to hear and determine in a summary way all the questions of law and fact. This is again very important. Question of law and fact. There are two types of questions of law and fact. In small claims court, both can be decided. Statutory mandate and may make such an order as it considered just and agreeable to good concise. Section 25. Now, if I am to find it, I have to go to that act, refer to section 25, then I will get an answer. Otherwise, come to LSO material, small claims court, any question, ready with the answer. To ensure that the court meets this mandate, section 27 relaxes the rule of evidence and empowers the court to admit any oral testimony and any document or other things so long as the evidence is relevant to the subject matter of the proceeding. This is despite the common law prohibition against the hearsay evidence. Kindly mark these words, highlight these words, write Q behind or above these paragraph. However, under section 27(3), the court will not admit testimony, documents, or other things that would otherwise be inadmissible by reasons of any privilege under the law of evidence, that is lawyer, client, or public interest privilege, or that are inadmissible by way of statute. Inadmissible, not required. One place where hearsay evidence are admissible. Those are small claims. But please, 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 do not subscribe to this idea. Just keep it as a piece of information for the purpose of exam, because it will be hard to get accepted and hearsay evidence in the small claim courts itself. That is what I have learned. Now, this is you will get definitely a question. That is my intuition, or say my judgment. Now coming to the last 4 lines of next paragraph. Gap rule. Kindly write down gap rule. There can be a question on this. Last 5-6 lines, the Court of Appeal considered the question of whether summary judgment was available in small claims court and determined that this was a deliberate omission from the small claims court rules, and thus the gap of rule R Rule 1.03 sub Rule 2 could not apply. The Court of Appeal for Ontario has subsequently ruled that the gap rule could be used to permit pre-trial orders for inspection of property in certain circumstances. So in certain circumstances, if the rule are talking something else, or there is a disparity in 2 rules, where we are talking, please don't quote me in divisional court. Constrain yourself up to small claims court. We are talking about the rules of the small claims court. Rules of small claims court do permit us to take in our mind that wherever there is a gap, inconsistency with respect to the given scenario in small claims rules, small claim court rules, then that gap can be filled by the court itself. That is what it means precisely. An appeals lies to the divisional court from a final order of the small claims court in an action for the payment of money in excess of 3,500 excluding cost, or the recovery of possession of personal property exceeding 3,500 in value. No appeal is permitted where the amount does not meet the minimum required. I filed a claim against you, anybody of you, 35,000. One thing you remember? Good. Court awarded me 2,500. I'm master of my own case. I can claim anything. I claim 34,000 from you on account of anything, A, B, C, D. Court just awarded me 2,500 as a compensation. You need to pay me 2,500. I was aggrieved. No. This is not good. I claim 35,000. Court has awarded me only 2,500. What is this? I should be heard. I should go and appeal. I should file a review, something like that. 2,500 is not acceptable to me. What is to be done? Nothing. Go back home, sit, relax, and accept it. Okay, now the next case. Court awarded me 3,600. I claimed 35,000. Court only awarded me 3,600. I'm not okay. I want redressal, further redressal of my grievances. Okay, go to the divisional court. Why? This is a confusing point for LSO exams. Generally, whenever the appeal mechanism from a small claim courts to the divisional court comes, the minimum threshold is $3,500. If amount of compensation awarded is less than $3,500, then you cannot appeal. You have to accept, make any number of hue and cries. You are not going to be heard henceforth. This has been finally adjudicated, decided. You are to adhere with it. But if it is beyond 1 rupee 3,500, it gives me an opportunity to go to the divisional court, file an appeal whatsoever. I do not say appeal, anything. So any petty matter cannot be taken to the divisional court. That is what I want to say. Why I have taken so much time in explaining this, please never get confused with 35,000 or 3,500. I tell you my weakness. I was knowing, I have read it in my, before when I was studying. But when I was doing some practice, revision, I became perplexed state of mind. 35,000, whether it was 35,000, it is incorrectly mentioned. No. It is correctly mentioned. It is 3,500 only for the purpose of appeal. So these two questions examiner can play with you. Why so? Why examiner plays with a student? I have an answer for it. Examiner is looking for content value. And that content value comes not with a rapid reading, with a discipline, consistency, LSO material. Otherwise, minimum competencies do require go and read all the acts, then go for exams. This is something big favor done by LSO so many persons. If you go like in the beginning of there are so many persons, big scholars, big lawyers involved in the drafting of this LSO material. So my humble suggestion to all of you is please do believe LSO material. It is correctly written. I do not find any anomaly into it. If you find, please bring it to my notice, or you can very well bring, if you are sure enough, you can bring into the notice of LSO. Now let us move further. Where we were? Okay. We have done with small claims court. Now Ontario Court of Justice. I made a ball statement in the beginning. Ontario Court of Justice is not a court of justice. No. I told Court of Ontario. Court of Ontario. Please do not confuse Court of Ontario with Ontario Court of Justice. Words are similar. That is why when we read in random, we are not concerned about the court. Then we forget. That is why I tell you, Court of Ontario is a court of record. Not a court in its true sense. But Ontario Court of Justice is part of hierarchical system. Now let us read about Ontario Court of Justice. The Ontario Court of Justice has its heads and president, the Chief Justice of Ontario. The similar provisions are there, so I won't waste much of the time. Of course, if you keep on studying the chart, you will find out that this is the platform which is usually connected dealing with less serious crimes. Can you hold on for a second, please? All apologies at my end. I told you there was something emergent. That is why I took your time. Sorry for that. And let us move further. This justice. One thing is that Ontario Court of Justice, apart from dealing with the code of criminal code, criminal code. Criminal code is a federal law or a provincial law? Anybody can help me? I'm not taking tests. Anybody can come, whether it is a federal law or a provincial law. Let me tell.
Federal.
Federal law. So in federal law, there are two types of offenses: indictable, non-indictable. Generally, for non-indictable offenses, generally I have used the word. In non-indictable offenses, Ontario Court of Justice is competent to hear the matters. Of course, there are particular sections. Which sections are there? We will come across once we will be going into criminal law. There, I will giving you a chart which what sort of cases under which section needs to be dealt by Superior Court of Justice and Ontario Court of Justice. Here, for the purpose of that, in today's world, all the governments, all the political systems are very much concerned with youth criminal justice system. How the youth of the nations, youth of the world be dealt. What I should use? Sympathetically? No. Considerably? No. At a greater speed, in a good manner, and of course, as per the provisions of the Act. What is that? Youth Criminal Justice Act. So, Ontario Court of Justice is always remembered, apart from its big role for youth justice court. If anybody asks you which is youth justice court, Ontario Court of Justice. Ontario Court of Justice is a youth justice court for the purpose of Youth Criminal Justice Act. Designated court we call it as. Designated court we call it as. For the family matters, Children Law Reforms Act, Youth and Family Services Act, I am reading. This is a designated court. So in the very beginning, I told you, unless prescribed by the statute. Now the statutes have prescribed Ontario Court of Justice as the proper forum for adjudicating the matters coming within the purview of these acts, with just exceptions. What are those just exceptions? We will be studying if need arises for this. Now, Ontario Court of Justice is done. Let us go to specialized. Very important, very easy, simple, one-line teaching. One-line teaching. For speedy trial, not trial, trial is the wrong word, for speedy disposal of the matters pertaining to certain matters, specialized courts have been formed. For speedy trial of certain matters, those are known as specialized courts. Toronto is one great city where maximum number of people are living, and people do think in these days protest with respect to the medicals in Canada is going on in Toronto since last more than 2 years. They are saying we are the biggest taxpayers. A big part of revenue comes from Toronto itself, and we are provided with less of the facility with respect to the taxes paid by us. They have their own demands. Now, keeping in view that spirit in mind, the specialized courts have been formed in order to advance. You know that Toronto happens to be the financial hub of Canada. If I call it as, of course, I do not know whether it is called or not, financial capital of Canada. That is why in Toronto region, specialized courts have been formed for some specialized purposes for the speedy disposal or adjudication of certain matters. What are those matters? One is pertaining to commercial. Another are estate. What are the commercial matters? Kindly mark two things in this. I am not going to read it. Paragraph 2 on right hand side, July 1, 2014. This commercial list was prepared on July 1, 2014. Kindly mark this date. You never know. There is a question with respect to May 2014. Whether this list which I am going to discuss is applicable, the answer is no. Kindly mark, highlight this date. The commercial list is governed by the frequently revised consolidated practice direction concerning the commercial list, the current version of which came into force on July 1, 2014. Now you need to club this July 1, 2014 with these points. What are those? Bankruptcy and Insolvency Act, Bank Act relating to realization and property dispute, Bulk Sales Act, Business Corporation Act, Canada Business Corporation Act, Companies Creditors Arrangement Act, so and so on. The receiver's application and all interlocutory motions to appoint and give directions to receiver and receiver managers, Securities Acts, credit unions. You can read it at your own, but mark this list, tag and flag this list. I have prepared this tag. The simple tag I have prepared, I have written it as commercial list. Now I will put it over here. I will show you after putting just, I have a purpose for it. I have placed another tags as well. I will show you the purpose. Now I have placed it like this. Why so? Let me see. Can anybody remembers this list? You read it 100 times. Of course, few persons in this world has got photographic memory. I do not have, or most of the people on this earth do not have. If I'm not of photographic memory, I have to use this tag. Once this tag is there, I close this book. This tag is still there. Question is there with respect to commercial list. Directly open it, go to commercial list, answer your question, you are comfortable. There is a purpose of explaining this process. Kindly use small tags and use these at appropriate place. This commercial list is of utmost importance if a question is there. So let me say you one thing, very at ease. This LSO exam is more of a methodology. And let me say you, from my experience and from the data I have collected from the various persons while discussing, why pass percentage is higher in June, lower in this March and November, say 8 to 10%, LSO says so. I'm not the last person. They say higher, I have joined the words 8 to 10%. Because here is a pertinent fact to tell. That pertinent fact is that in June exam, generally the student passing out from the Canadian universities, any one of you may be passing out from there, come into these exams because all of the law students of universities, maybe from any university, I won't name any particular university, they have also to become barrister and solicitor. They have to give the same exam which you are giving being an international lawyers, or maybe you may be like a Canadian law student, Canadian lawyer. Then they come, they appear in the exam, they get more marks and increase the percentage. Why they get more marks? Why we cannot get more marks? Because this is the key point which I am going to tell you. They are more methodological. Universities have taught them to be methodological. They go to the class for the whole year, for whole of their years together in semester system or in annual system. They learn the methodology. All the indices are prepared by, generally, the best indices I have come across, prepared by Toronto University people. Now I'm naming the university. Toronto University people. Even you can be one of them to prepare the indices. They call for it. To prepare the indices, every time a call is given, You can be part of that team. Of course, there are certain criteria which you need to fulfill. Then you can be a part of that. What are indices? To be methodological. I told you that certain students bestow upon indices for attempting 100 questions. So this is a free knowledge which I am giving you. Being methodological in LSO exam is more important than to be intelligent. This is my statement. I subscribe to it. You may agree or you may have different opinion. I appreciate and respect your opinion, but still, this is based on my experience. So my experience says being methodological is much more important. That is why I put took time and put emphasis on the commercial list and put a flag upon it before you. I have another flag just to show you. I have prepared for it. I will keep on doing it. I will put on here. Put it over there. Next list. I'm going to explain. I'm doing it purposely so that you may start following this habit. Now let us turn to next page. We are at the estate list. Commercial, there is one another date. The date remains to be the same, July 1, 2014. On the next page, I have covered this topic. Now comes the estate list. If any, from the unread part, if anybody has got any doubt later on, they can put. The estate list. The estate list, estate matters. What are the estate matters? Somebody dies, how his estate should go. How his estate, his or her, please don't, I'm not gender specific when this is something, all apologies that I use this particular language, and that has become my habit during the course of 22 years of my practice in my home jurisdiction. So all apologies, I'm not gender specific. The estate list. The estate list pertains to those matters, how the estate of a deceased will devolve upon his legal heirs. It can be with a will, without a will. We are going to read the estate laws. Once we are a student of solicitors, if you have already passed solicitor exam, you will be good to know the estate list. So all these matters have been described here. Now, two rules. Kindly mark this list. This also came on July 1, 2000. And if examiner does a little, what should I say, that examiner plays with you, I should use this word, then he may tell you something about May or January 2014. January and July are similar. Okay. What was the date? Matter pertains to January 1, 2014. Specialized courts were not formed. So we will go by the other methodology. Say December 1, 2014, specialized courts were formed. Now specialized list is there. We will go by that methodology. Another point of catch is where we are in Ottawa. No. These lists are not applicable. Where we are in Toronto region. Okay, these lists are 100% applicable. Estate list, commercial list. Now this is again an exhaustive list. I will comment upon 2 or 3 topics over here. All matter, first point, all matters in dotted, all matters arising from rule 74 and 75. Estate rules. Now rule 74, rule 75, somewhere it is written. After this list, I will read it. Rule 75 governs the procedure for non-contentious estate matters. Non-disputed. This, you should keep a dictionary with you. Not in the exam. And NCA I refer in exams. In this LSO, I refer while reading study material at your place. In the class, you can keep it. or you can use your mobile, but in exams, mobiles are not allowed. You can take your dictionary if need arises for the same. In LSO exam, I have hardly used the dictionary. In NCA, I have used it many a times to make me at ease. Now, non-contentious estate matters, 74, 75, contentious, disputed. All matters arising under Rule 74 and 75 of the rules. Any matters comes is cup of tea of a state list to be adjudged by a specialized court. This is what we are going to learn today. This is something all about. Rest you can read everything at your own. These are exhaustive list, but I do recommend kindly go through this list sincerely. Case management. Next. Two tags we have put. I will show you. Two tags, little. Now, I'm good. From today onwards, I do not have to bother my mind about commercial list or state list. Whenever a question comes, July 1, 2014, I will forget by the end of this civil litigation, because there will be more than 200 odd dates to remember. I cannot remember all those dates. If you are good enough in remembering all these dates, then you are very good, more good than any other person. But still, for date purposes, if any confusion is there in the exam, please do refer to LSO material. That is what I can suggest you. Now comes to the case management. Case management is a system designated to reduce the unnecessary delay and cost. This is very, very simple. Hardly there will be any questions. Case management is discussed in chapter 34 in detail. That is why I'm not taking it up. There is a prescribed date of January 1, 2010. We will discuss once we come to the case management. Now in indices, you will come across page number 146 and of course the page number of case management chapter, that is of chapter number 34. Go by my first methodology of using indices. 146, you are immediately recalled. We are talking about the organization of the groups. 140 something, 200 something in chapter 34, referring. You will not shift yourself to chapter number, page number 146, but you will go to page number 200 something in chapter 34. That is also one of the tactful handling of indices. We are going to learn. I'm just giving one instance because relevant with the study material is again very important. Next time onwards, I won't be taking this time. This is the methodological theory. That is why I call it as a regular class. We are in the last minute of the class, but I will, with permission of yours, can I take 5 to 10 minutes of yours more? If anybody will say yes, I will go ahead.
Yes, sir.
Thank you for your consent. Thank you. Let us complete this chapter. Case management, we are not bothered. We will study in chapter 34. Simplified procedures. Here comes the catch. One question, two questions. Well, I do not say in exams there will be one question, two questions. There may be no question. But I have two questions over here. So that is why I have sought your intervention and taken time from you. 74, 75, 76 now. You will also forget. I have forgotten. I have cleared my exams. Now I'm teaching. So please, please, please do remember certain things. Now this $200,000 threshold you have to. 2 lakh is there, okay. Above 2 lakh, different rules are there. What is that 2 lakh? Let us read. 35,000 we remember. Now 2 lakh we will remember. Few things I will ask you to do. Under 76, a simplified procedure applies on a mandate basis, mandatory basis. You have already done NCA. Must, shall, should, would, must, anything. You should interpret in the mandatory, ought to, or recommendatory natures. Mandatory, ought to, or recommendatory nature. Mandatory, must, ought to. If a lessor has asked you something, it is generally ought. As a lawyer, ought to file your report by this date. PR. Do not file, face the administrative suspension. So it is ought to. Now it is not, seems to be. So under 76, simplified procedure, mandatory. Basis to an action where plaintiff is claiming 200,000, 2 lakh or less, exclusive of interest and costs. Kindly remember, exclusive of interest and costs. Or money or real or personal property, it does not apply to a class proceeding, construction liens. What are the exceptions? It does not apply to a class proceedings when a group of people are there. Construction liens, we will understand in real estate. What are the construction liens? Although trust, first my tag has come. Trust claims under the construction liens can be brought under the simplified procedure. Case managed actions under 77. Now, next is very important. Please highlight where a jury notice has been delivered in a claim for slander, libel, malicious arrest, malicious prosecution, or false imprisonment. Question. Kindly write it as a question. We need to see in the days to come how the question will be framed, but please do mark it as a question. It can also be used on an optional basis. First was the mandatory basis. The areas we have read: slander, libel, malicious arrest, malicious prosecution, false imprisonment, but does not apply to construction liens, and then class proceedings under the Construction Act. Then where the rest of the things are? Optional things. First we have read mandatory, then we have read optional. Questions will be twisted between mandatory and optional. Questions will be twisted between optional and mandatory part. It can also be used on optional basis where the amount of claimed by the plaintiff exceeds 2 lakh if the defendant does not object to the simplified procedure in the statement of defense. Even if the defendant objects, the plaintiff can continue under the simplified procedure by abandoning the amount of the claim in excess of 200,000 in reply. Very nice principle. I will say the nicest principle a judicial system has introduced. In my common law jurisdiction, this is not there. If it would have been there, my clients' cost cutting have been more than what they claim. Suppose it is 200,000 above, 2,000, 205,000, 205,000, just 5,000 more. I will have to go to the next court. I will have to adopt the, not the simplified procedure, but the detailed procedure. Steps of key steps in civil litigation, so many steps. Simplified procedure, number of less steps are there. Cost cutting is there. So if I'm go simplified procedure, my cost will be many fold less. Once my cost will be less, I can decrease my claim by way of $5,000. I decrease my claim, my cost will be cut. Ultimately, I will be benefited. So this is the benefit of simplified procedure. There is a specific chart. Once we will come at appropriate place, I will provide you that as well. The purpose of this rule is to reduce the
Sir,
cost.
so
Yes, please.
sorry to cut you, sir. So basically, sir, this has mandatory, optional, and exceptions. All the three things, right?
Yes,
This way.
yes.
Okay.
And you have to judge in the exam where you are in mandatory provisions, in exceptions, or in optional. That you
Correct.
have.
Okay.
That is the application of LSO material in the exam with a flick of a second. I will use this word time and again. This is not my regular word, but still, flick of the second means to say, I have seconds to answer the question in the exam. Your watch should always be clicking behind your brain, always in LSO exams. Once this clicking stops, you lose your exam. Okay, now last but not the least, but one question. COVID-19 pandemic adaptations. Curse. COVID has been a curse. And I do not have, if any benefit has been derived out of the procedural adaptabilities, I do not acknowledge that. It is a curse. But still, we have to acknowledge that courts have adopted. We have to acknowledge, not appreciate. Acknowledging, I have to accept. Appreciation, I do not, because it's a curse. This is my personal opinion. You may have yours. Similarly, the Superior Court of Justice, all hearings are initially suspended except for urgent matters, and remote video and audio technology became the only hearing method. Counsel should ensure they consult the latest version of the consolidated notice to the professional litigants, accused persons, public, and the media effective May 2020. COVID consolidated notice. The court has also issued a useful best practices and etiquettes for remote hearing, which will likely remain in effect for some time. This date, you have to remember that May 19, 2020 was the date when COVID consolidated notice came into being and a new procedure was adopted. And what is that procedure written henceforth? That is little less applicable nowadays, so less chances of getting a question, but still this is a question of May 19, 2020. If the matter pertains to any of the COVID directions issued by the courts or the government of Ontario or the federal government. So we have reached the end of the good class in which I was heard in a peaceful manner. That is, when once you are speaking, let me say you at my end. If you have good listeners, you are successful. And you are very good listeners. You have given me your valuable time. I'm really thankful to all of you. And still, if you have any doubts, we are end of the chapter. We have completed chapter 1. Of course, we could have saved 1 hour, but I assure you that 1 hour is going to play a big role in attempting your exam question. That is why I have taken those things in my first class. I wanted all the persons who may watch my video on this YouTube channel or anywhere else, they will have access to all this material. This should not be sub judices to my professional part. So that is why I have kept these things for the first class, and it will not be repeated, but your questions are always welcome. If you have any question for today's class before we end up the class.
Sir, so tomorrow you will be taking another subject, right? Criminal, or which subject are you going to take tomorrow?
No, sir. At the cost of pardon, I already submitted that we will be first completing civil litigation. I'm giving my demo, if I'm to say demo class. Of course, it's not a demo class, it's a regular class. I have not changed anything into it. I will not be taking up this class again for my regular students. Of course, I will be providing recording to them, whosoever will come late to me. But tomorrow we will be continuing with chapter 17.
Okay.
We will be tomorrow we will be completing chapter 17, chapter 18, chapter 19, and what not. Chapter 19, I suppose we will be completing 4 chapters. Then I will try to complete 20th chapter as well tomorrow itself. So we will be completing 5 chapters in this free introductory people used this word. So free introductory classes, we will be completing 5 chapters of civil litigation, meaning thereby 25% of civil litigation and the basics. So my humble submission is, I request you, all of you, tomorrow onwards, I will be seeing in these 5 classes. Tomorrow onwards, if I will have a reader, different reader who can read a few parts for me of this LSO material, we will be uh, much ahead what we are doing. We will be covering most of the parts. We will be taking more doubts. So if few people on voluntary basis can help me in reading this material, this will be quite helpful to me in days to come. This is my humble request. Anything else which you would like to know? Otherwise,
Good
it's a
morning, sir.
pardon.
Good morning, sir. How are you?
I'm fine.
Yeah, thank you for your all the efforts you have taken towards. But I was just requesting the sources of the LSO material where I can retrieve it because I don't have any material you are reading right now.
Okay, so sorry for that. I have not discussed this point. I will discuss right away. Ma'am, you have done like this NCA and now you are a LSO lawyer licensing candidate.
Sir, I'm just fresh here. I have not got any idea about this. I've just done my LLB from India and I have not even practiced. I don't have any experience in the legal background. But as a just a student, I just out of my curiosity, I'm asking that maybe you can guide me in person instead of wasting
No,
everyone's
no,
time. Maybe
I
we
will
will have
write.
chat.
No, I would like to answer this question in recording itself because this has been asked to me by so many people from India and abroad as well, from so many countries. One thing is to be clear: these classes are applicable for NCA qualified students. So this LSO material cannot be provided by me. This LSO material, of course, it is the same, but provided by LSO because it is their copyright to LSO candidates.
Got you right. So I think I must go for NCA first before coming to the LSO first. So my first
Yes.
step should be clear before. So I will connect you for that. I appreciate your this answer.
But you're most welcome. Anybody is most welcome to attend these 5 classes because in the years to come, if you are thinking about Canadian perspective, you have to do this.
Definitely, sir. Appreciate. Thank you. I'll be in touch with you in due course of this.
So nice. Thank you very much.
I appreciate.
Anybody else to have any doubts, any questions, any personal things, or anything about the class? I would welcome any suggestion in the group or otherwise as well. And believe me, you all are very good, although I'm not conversant with everybody, but still, to be a good listener is the big thing, and you are a good listener. Thank you very much to
Sir,
all of
will
you.
there be
Yes.
any other charts you're providing for the future lectures like which you're discussing tomorrow?
Tomorrow, I suppose there are no charts. I will be providing
Okay.
henceforth. There are hundreds, there are not hundreds. Total LSO barrister and solicitors have got more than 150 charts of them, which are to be used in different subjects at different times. I have provided you with those charts which are really relevant to the contemporary study in these 5 classes. Once you get enrolled with me, I will be providing all the charts which will be elaborative enough, very elaborative. Certain charts are consisting of 10 pages each, and 10 pages each means to say you will be having direct question answers from those charts because those are really lengthy charts. You will have all,
Okay, sir.
but at appropriate time. Anything else I can help anybody with? Thank you very much to all of you. Good day and good night to whosoever is going to sleep. Have a good night's sleep. And God will bless you all. God will bless us all. We will be become you all people because I'm already there. You all will be barrister and solicitors very soon, provided you give me your 100%. I'm ready to give my 100%. Thank you very much.
Thank you,
Thank
sir.
you. Really appreciate.